Today was a big turning point in crypto that a lot of people probably missed. It was another one of those events where crypto expectations did not align with reality. Now more than ever, it's clear that US courts aren't going to care what crypto users think they're doing on crypto platforms. They don't even care about what the platforms say is happening on the platforms. Judges are just going to apply the traditional legal framework to the crypto landscape, whether crypto would have ever intended that or not. You thought you were lending your crypto? You thought you were just depositing your crypto? You thought you still owned it? Nope, you never owned it. You forgot the most important rallying cry: give me custody or give me death. Ready? Let's go. Today, we are going to discuss the recent judgment as to $4.2 billion worth of user assets in the Celsius case, how it even gets worse, conflicting past statements from the Celsius project leader, a look at a new upcoming Stableswap on Cardano, the December FOMC minutes, and some new allegations about Solana and FTX. If you grew up in the 80s and you are absolutely positive this is not a Cardano guy confronting the Grim Reaper, this is actually just Skeletor's little brother talking to his accountant, probably on a chilly day, or if you're finding value in these videos each weekday, please consider delegating to the Army of Spies stake pool, ticker AOS. Here's an opinion in the Celsius case that's surprising a lot of people today. It shouldn't be a surprise, though, if you've been watching this channel and you remember when we talked about this same issue in the context of something that popped up in the Coinbase SEC filings. So this case is about Celsius. It doesn't have anything to do with Coinbase necessarily. But before we jump into this, look at how many different law firms and parties are involved in this. Why are there so many parties involved in this? Because we're talking about a lot of money here. We're talking about something like $4.2 billion worth of crypto assets, just sort of an issue in this opinion, this part of the bankruptcy. So what's going on here is, of course, Celsius was holding a lot of crypto user deposits, and those depositors were sending their crypto assets to Celsius so they could earn interest. They were putting their assets into interest-bearing accounts with Celsius. And of course, what the crypto people doing this thought would happen, the crypto users of this platform, what they thought was happening was that they were just lending their money to Celsius and they would get that money back. They thought they were depositing their money in something that would feel kind of like a really high return savings account or something like that. And at the end, they would get their money back. And a lot of people certainly thought of this as them lending their money to Celsius. This is a problem for a bankruptcy court because whether Celsius owned those assets or the users owned those assets is going to determine what happens to them in this bankruptcy. If those deposited assets are owned by Celsius, then Celsius is going to use those assets to do whatever they need to during this bankruptcy. They've got a lot of creditors they have to pay off. And unfortunately, as we can see here on page 6, if the crypto assets in the earn accounts are owned by the debtors, the debtor here being Celsius, the account holders are unsecured creditors, and their recovery depends on the distributions to unsecured creditors under a confirmed Chapter 11 plan. So if those deposits belong to Celsius and not to the users, then Celsius is going to go ahead and hang on to those assets and distribute them out in the normal bankruptcy. And the users are going to be deemed unsecured creditors. This would mean that the users would be lower priority creditors. An entity like Celsius in a bankruptcy like this, they're going to have secured creditors. And if you're a creditor and you don't have a security interest behind the debt owed to you, you're going to be lower in priority than those secured creditors. which is very bad. In a bankruptcy like this, you do not want to be a lower priority creditor, which is exactly what the position that the users are going to end up in if the assets are deemed to be owned by Celsius. And we won't go through all the details. We'll skip right to the end here. Conclusion: for the foregoing reasons, the court finds that earn assets and earn accounts constitute property of the estates and that the debtors may sell stablecoins outside of the ordinary course of business. The court does not take lightly the consequences of this decision on ordinary individuals, many of whom deposited significant savings into the Celsius platform. As has been said repeatedly in this opinion, creditors' rights with respect to various defense to and breach of contract claims are reserved. Creditors will have every opportunity to have a full hearing on the merits of their arguments during the claims resolution process. So the court is finding that those assets that were deposited into these interest-bearing accounts are the property of Celsius. They are not owned by the users. This means the users are unsecured creditors. They effectively sold their assets to Celsius. They did a transaction where they gave their assets to Celsius and Celsius gave them an IOU, an unsecured IOU. This is a huge problem. Here's where it possibly gets even worse for the users of Celsius. I know you're asking, how could it be any worse? They're now unsecured creditors. They don't get their deposits back. They just get to get in line with a whole bunch of other creditors, and a lot of those creditors might be higher priority than them. That sounds pretty bad. It could get even worse. So you'll notice a couple of seconds ago, I used a very particular verb. I said that they sold their assets to Celsius. This is important. As explained below, the court concludes, based on Celsius's unambiguous terms of use and subject to any reserved defenses, that when the cryptocurrency assets were deposited in earn accounts, the cryptocurrency assets became Celsius's property, and the cryptocurrency assets remaining in the earn accounts on the petition date became property of the debtor's bankruptcy estates. So all of that part would be fine. It's this other part that is a bit problematic. Several creditors, in addition to the coordinating states and Washington, contend that if account holders transferred title to their assets to Celsius, then the transaction would have created a taxable event. Yet Celsius did not pay taxes on these transactions or issue tax documents to account holders. So here we have the states. The states want to get paid. They want their taxes because they're saying, hey, if the court decides that you transferred title of your assets to Celsius, that's a taxable event and we never got paid. Somebody's got to pay us. So here's what people are speculating. And of course, this is not tax advice. These are just random people speculating about this on the internet. Celsius earned deposits were held to be property of Celsius estate. Many earned depositors who thought they were lending were actually selling. Could be a tax apocalypse to add insult to injury for users of Celsius and other bankrupt centralized exchanges. And then we come down here. Somebody has a little bit more specific thoughts on this. If an earn account was a debt of Celsius, but a regular account wasn't, then depositing tokens into earn would likely be a taxable sale of tokens for Celsius debt. Holders who lost money in earn may be able to take a bad debt deduction, a capital loss. And later on, some other posters sort of added to this, pointing out that, yeah, but if that was a taxable sale and it happened in, say, 2022, but you maybe are you going to be able to write off this bad debt immediately, or is that going to be a forward-looking debt that you can eventually write off once you know how much you're going to get out of the bankruptcy? So you've definitely got people are speculating maybe there's a big timing problem here, that people are going to be stuck with this taxable sale of the tokens when they thought they were lending them. They actually created a taxable event for themselves because the court is deeming this a sale of the tokens, but they won't actually know how much they're going to get out of the bankruptcy until later. So is this going to be a forward-looking deduction to offset this taxable event? Pretty bad situation. I think the big problem here, though, is the same problem that everybody seems to always get into in crypto. One of the big problems, at least. They give up custody to their assets. You notice none of this happens if you don't go after those sweet, sweet yields. If you just keep custody of your tokens, if you tell these centralized exchanges, give me custody or give me death. This doesn't happen. And you notice you could actually be in a scenario, given this opinion, you could actually be in a scenario where you thought you owned crypto and you never owned crypto. We knew this was going to happen because we covered it on this channel when this exact possibility popped up in the Coinbase SEC filings. They let everybody know, hey, if you have assets on Coinbase and we were to potentially go bankrupt in some way, you might be deemed to be an unsecured creditor. Coinbase just straight up told you this could happen even on Coinbase. So you could end up in this scenario. Let's say, hypothetical, you buy assets on Coinbase, then you deposit them in some kind of interest bearing account on Coinbase or some other centralized exchange. You could go through that whole process thinking you bought crypto, when in fact it was a deposit on Coinbase, and Coinbase is telling you, no, that's not actually yours. You're just an unsecured creditor in case we go bankrupt. Then you put it into an interest-bearing account. And this opinion tells you, in that case, you're very possibly also just an unsecured creditor. Nowhere in that timeline did you actually own the crypto. It was owned by the centralized exchange, and then it was owned by whoever was hosting that interest-bearing account. You never owned the crypto. Obviously, a lot of Celsius users were surprised by this opinion today, as you can tell from this post, but it looks like they weren't the only ones laboring under this mistaken expectation. This poster says, there's really no question here about whether we legally own our coins when held at Celsius. Alex Mashinsky, who is the project leader of Celsius, makes it perfectly clear that we do. Otherwise, it's 100% false advertising. And listen to what Alex has to say right here.
So when you give us Bitcoin, it's not like it's ours, right? It's yours. Legally, it is still your Bitcoin. The only thing we do is when you lend us your Bitcoin, we lend them to people who pay us interest. When they return them, it goes back to the wallet and it's still yours from that wallet.
So there's an important moral to this story. You cannot trust the projects, even if the project tells you, hey, it's okay to deposit your assets here. You still own them. They might be wrong. They might be mistaken. Some federal judge might completely disagree with them because they don't know. The projects don't really know. Even if they're the most cutting edge legal experts, even if the CEO of the project happens to be a cutting edge crypto attorney, he might still not know because the law is still developing in crypto. Nobody really knows where crypto law is going to go. But what we do know is that really big projects can be 100% wrong about what you're even doing on their project. A lot of people, based on probably statements just like this, thought they were lending their crypto to Celsius, or they were somehow retaining custody of their well, they knew they weren't retaining custody, but they thought they were retaining ownership based on statements like this. They thought they still owned the crypto, that they were just, giving it to this middleman who was kind of loaning it out for them and paying them an interest rate, something like that. None of that was right. The court said you were selling your crypto to Celsius. And I don't think that's what anybody thought was happening. Give me custody or give me death is a principle that is operable globally in crypto. But coming back to Cardano proper, you might be asking yourself, hey, Ardana seems to be gone. Are we going to get some kind of stable swap, some kind of stable coin DEX, some place where we can do these same things, but with stable coins? Our friend Subcritical to the rescue. He's going to tell you all about this new project, Teddy Swap. He says, I've been seeing a lot of questions about Teddy Swap. So let's take a look at what's inside this teddy bear. What is Teddy Swap? Is it similar to MinSwap and Sunday Swap? When is the release date? Who is the team behind it? I won't go through any of the details here because Subcritical does a great job. If you want to learn about Teddy Swap, you can come on over here to this thread on Twitter from Subcritical. I know. Some of you are probably jumping up right now saying, hey, you just said give me custody or give me death. But yet we often talk about DeFi and crypto, and DeFi is a big part of crypto. And DeFi projects often ask you to give up custody in order to make use of the functionality on their platforms. These are all true things. For me, I try to give up custody as infrequently as possible and only temporarily. I try to get in and out as quickly as possible to minimize the chances of any of those bad effects of giving up custody. We also now have the FOMC meeting minutes and economic projections from the December meeting. These just came out today, but they actually reflect what happened in the December meeting of the Fed. And the funnest part to me is actually the dot plot down here. So this is a really good graphical representation. Everybody involved in the meeting just kind of votes about where they think interest rates are going to be in the future. And you can see very plainly from this dot plot that in 2023, the vast majority, all but two, what is that, like 15 out of 17, I think, people giving their projections see the interest rate being above 5%. And then, of course, all but two see them coming back down in 2024. And, they've got, the typical optimistic projections as to what happens back in 2025. But you notice in 2025, they're still not down to their 2% type numbers that they're constantly trying to hit. Longer term, they all see things, closer around 2.5 and in sort of this range. But even in 2025, only like one participant sees them being under 2.5. Everybody else sees them much higher. This person still sees the interest rate as being very, very high in 2025. But of course, these are a little longer range, and typically things change pretty drastically. These are I think, in my opinion, it's optimistic to think that you could even predict this far out what the interest rates are really going to look like. But I think this year and next year are pretty relevant. This gives you an idea of what they're thinking. And 15 out of 17 people do not think interest rates are coming down in 2023. And even in 2024, I mean, all but two people still think we're going to be above 3.75-ish. They all think we're going to be up around 4 and higher even in 2024. Finally, you might have thought that things couldn't possibly get any worse for one of Cardano's former biggest competitors, Solana. Things have gotten pretty bad for Solana since the FTX blow up, but it looks like the suspicions of everybody in crypto that FTX was helping to prop up Solana artificially. Those suspicions seem to just keep getting deeper and deeper. Here's a post. There is on-chain evidence that SBF and Alameda were behind millions of dollars of Solana NFT purchases in October 21, boosting trade volume and floor prices across multiple projects on Solana. And it's all going to be about this address right here, 6GFI. And here they show a bunch of different Solana projects, I assume, where this wallet had picked up a lot of NFTs. Down here further, he says, throughout multiple weeks in October 21, that wallet, 6GFI6, bought 500 plus NFTs, including many blue chips in the 5-figure range. So we're talking, I assume they're talking dollars. So we're talking about NFTs, $10,000 or more. If we're talking 5-figure USD range, nearly doubling some of the floor prices. The purchases and rise in many floor prices got a lot of attention at the time. The wallet is connected to SBF. SBF bridged from Ethereum to Solana back in January 21. The receiving wallet was seeded millions in Sunny tokens by this wallet, 6GFI6. Multiple tagged Alameda addresses deposited in and withdrew millions from 6GFI6. So I think we can assume that did have something to do with Alameda and or SBF. FTX's US NFT marketplace opened up the day of the sweep. This is literally the first wallet I looked into on Solana connected to SBF and Alameda. If I have time to dig into this more, I'll see what else I can find on this chain. Currently, all of these NFTs are in the FTX US NFT wallet. So if you are a creditor to FTX in the bankruptcy proceedings, not only do you own a bunch of Bored Apes, you also own hundreds of Solana NFTs. I think we keep finding out that more and more, obviously, Bored Apes. He's probably talking about the Ethereum NFTs that are also owned by FTX, but he's also talking about hundreds of Solana NFTs. More and more, we keep finding out that FTX might, and probably misappropriation of user funds in FTX might have been I'm saying might, we don't know this for certain, so I'm not stating this as fact, but misappropriation of those funds might have been a much bigger factor in the illusion of success of Solana than we even knew. I hope you're having a great week, and I'll talk to you tomorrow.